Imagine crossing the road or sending your child to school and someone fails to take reasonable care. Who's responsible when harm occurs? Let's dive into the world of duty of care and find out together. But wait, what even is a duty of care and why does it matter? Historically, to establish liability in an action in negligence, it only needed to be established that the defendant had failed to take reasonable care and that failure to take reasonable care had caused the plaintiff's injuries. However, Lord Esher in Heaven and Pender established that a duty of care can exist even in the absence of a direct contractual relationship, particularly when one person's actions could foreseeably cause harm to another. As such, in Australian negligence law, a claimant must prove 4 things: duty, breach, causation, and damage. Duty is the gateway. If no duty exists, the case stops there. At its core, a duty of care is a legal obligation to take reasonable care to avoid foreseeable harm to people closely and directly affected by your conduct. This idea traces back to the famous neighbour principle established in the landmark case of Donoghue and Stevenson, whereby you must take care not to injure your neighbour, those likely to be affected by what you do. Initially, the ANTS approach per ANTS and Merton London Borough Council was influential in early civil cases in Australia. This test focused on foreseeability and proximity and then considered policy factors to potentially negate or limit the duty. However, the ANTS approach has been rejected on the basis that the concept of proximity was too expansive. As such, the decision in Sullivan and Moody established that a duty of care and negligence is not solely based on foreseeability. The High Court instead asks whether, in the specific relationship, it's appropriate to impose a duty, which is an analysis guided by salient features which are exhaustively listed in Caltex Refineries and Stavar. To establish a duty of care, a plaintiff needs to demonstrate that they are part of a group of people who would likely be harmed if the defendant fails to provide reasonable care. It's fair to expect reasonable care, and the law recognizes this by holding individuals accountable when their actions could foreseeably harm others. For example, a landowner owes a duty of care to tenants, ensuring that the property is safe and habitable. Furthermore, a duty of care can include an obligation to act, as in Richards and Victoria, where a teacher breached her duty by failing to prevent a schoolboy's injury. So remember, duty of care is a doorway to negligence, and that duty asks, do you owe care at all?
So, now that we've explored what duty of care actually is, let's have a look at the elements in determining a breach. In establishing a breach, we must look at the statutory authority, the Civil Liabilities Act 2002, New South Wales. More specifically, Sections 5B and 5C. Section 5B, subsection 1, outlines the general principles in determining whether a person has breached their duty of care. Firstly, the plaintiff needs to prove that the risk of harm was foreseeable. What is a foreseeable risk, you ask? Well, a foreseeable risk, per Sullivan and Moody, is a foreseeable, real, and not far-fetched or fanciful possibility of harm. As articulated in Chapman and Hurst, the reasonable foreseeability test addresses the question of to whom a duty of care is owed, focusing on its existence. The precise events or sequence of events is not what is needed to determine a foreseeable risk, but rather the general character of what occurred. Secondly, the risk must not be insignificant. Judge of Appeal McFarlane in Shawn and Thomas 2010 referred to the not insignificant test as imposing a more demanding standard than the not far-fetched or fanciful test. This is a low threshold to meet. Lastly, Section 5B, subsection 2 of the Civil Liabilities Act states that in that circumstance, a reasonable person in the person's position would have taken those precautions. The court would consider the following when determining whether a reasonable person would have taken precautions against a risk of harm. But that's not all. Section 5C of the Civil Liabilities Act elaborates on determining what precaution a reasonable person would have taken, and that an existence of an alternative method of taking action does not automatically establish liability. The section outlines that the court will consider the following. But wait, are you a professional who has breached their duty of care in a professional capacity? If so, you will actually be held at a higher standard of care than of an ordinary reasonable person. For professionals, Section 50 of the Civil Liabilities Act lifts the bar to peer professional opinion. If the conduct matches a practice widely accepted by competent peers, it's usually not negligent, so long as the court does not find the widely accepted opinion to be irrational. In exploration, in Rogers and Whittaker's, the High Court specifically departed from the English Bolam principle, which allowed professionals to avoid liability if they acted in accordance with the practice accepted by a responsible body of their peers. Instead, Rogers and Whittaker established that while professional opinion is relevant, the ultimate decision on whether a professional has breached their standard of care lies with the courts, which will apply an objective standard of what a reasonable person with that skill would have done in that circumstance. In essence, to prove breach of duty, a plaintiff must demonstrate that the defendant failed to exercise reasonable care in preventing foreseeable harm. Oh, and remember, pros are judged by their peers. To steer clear, be sure to meet the widely accepted practice so liability doesn't hit you in the rear. Now, let's look at how the courts have recently made findings of a breach of duty of care. In State of New South Wales and T2, the State of New South Wales was found liable after a 14-year-old student who was seriously assaulted by fellow students shortly after school had ended. T2, who was the victim, became aware that afternoon that other students were planning to attack him. He attempted to go back to school, but at only 3:15 p.m. the gates were closed and no teachers were seen in the area. These fellow students therefore prevented access to any buses and led T2 to where the assault happened, with the main perpetrators only recently returning back to school after a lengthy suspension due to violence. T2's claim for negligence was successful. However, the state appealed the findings on breach and causation but not damages. The Court of Appeal dismissed the appeal. It was held that the school's duty of care to prevent foreseeable harm extended beyond the classroom depending on the circumstances, and that this duty was breached as the school failed to ensure staff supervision for a reasonable period after school.
How well do you understand a duty of care now? Have a read of the following example scenario and see if you can figure out whether high school teacher Jeremy owes Nashita a duty of care. Oh, and to see how well you've been paying attention, have a crack at our Kahoot and quiz yourself now. Thanks for watching!